How's everyone doing? All right. If at any time during the proceedings you cannot hear me, anyone, feel free to give me a signal, okay? Don't feel inhibited from doing such. So good morning. Today is Tuesday, January 28th. Welcome to the First District Court of Appeals. It's an honor, pleasure, and a privilege to be here with you today. And we have 4 cases that are on the docket this morning, one of which has submitted. The first case that we have is case number C240281, State of Ohio versus Watley. If attorneys can please identify themselves and their readiness to proceed. Good morning.
Norbert Wessels on behalf of the state, the ready to proceed, and if I may, join me at the council table, Candace Career, she's named through, I just want to introduce her.
Okay. And it's Candace
Candace
Career?
Career.
Okay, good. Welcome. Are you arguing or are you observing? Okay, all righty. So we'll treat you gently. By default, right? All right, the next case we have is case C240189, Tyra versus Griffin. If attorneys can identify themselves and their readiness to proceed. Okay, did I miss something? Oh, okay. Good morning. It's okay. Don't even worry about it. And so is either pro se or someone representing Tyra here today? Okay. Okay, and so you're the one that entered the limited appearance this morning. Is that correct? Okay, and we understand. All right, thank you. No worries at all. Okay, case number 240307 in Ray CR. If attorneys can identify themselves or parties and their readiness to proceed.
Brad Berry, attorney for Raleigh.
Okay. All right, thank you. Thank you both. And the last case we have has submitted on the brief, so they will not be arguing this morning, which are cases number C240651, 676, in Ray SF Children. So we're going to begin with State of Ohio versus Watley. And Attorney Nelson, good morning again. Would you like to reserve time?
Yes, please, 3 minutes for rebuttal.
3 minutes, is that right?
Yes,
Okay, you can start whenever you're ready.
thank you. Good morning, Your Honors. May it please the court. Good morning, opposing counsel. Sarah Nelson again on behalf of Mr. Watley. Mr. Watley is a law-abiding citizen and among the people that the Second Amendment unambiguously covers with its promise that the right to bear arms will not be infringed. Excuse me. However, his rights were infringed in this case due to Ohio's minimum age requirement and the improper handling of a firearm in a motor vehicle statute. Excuse me. Because it's our
So on the
position that...
first, just for clarity, okay, on the first assignment of error, the infringement, what you object to is the age. It's the disqualification based on age.
Correct.
Is that solely what you're objecting to, what the basis of your constitutional argument is based on?
We've raised constitutional challenges to the minimum age requirement under the concealed carry law in addition to the improper handling statute.
For the first assignment of error, that's all I was talking about.
There are 2 issues under the first assignment of error.
Okay, so you raised, okay,
Yes,
understood.
both.
Okay,
Yes.
thank you.
As both they fall under the same framework, and they are interrelated because...
And they're interrelated, one bleeds into the other, yeah.
Absolutely.
And just as a follow-up, you're not arguing that any restrictions on, like, if the state said everyone had to have a concealed carry permit, you wouldn't say that that was a Second Amendment violation, right? you're just arguing that because they're requiring somebody, they're not allowing a concealed carry for a certain age group, that's a Second Amendment violation?
Correct.
Okay,
There
so the
is-
state can regulate concealed carry?
Absolutely, yes.
But it would, you're just saying that because it is geared toward a specific age group, that that's the violation?
Yeah, the only thing we're attacking under the concealed carry law is the minimum age requirement.
Okay.
The fact that you have to be under the age of or you have to be over the age of 21. In our view, adults between the ages of 18 and 20 should not be treated differently, and they are under the law in this case, and we think that that's unconstitutional. How do we solve that question? We turn to the United States Supreme Court precedent, Bruin and Rahimi, to address this issue, which this court, I know, is well aware of, given its recent cases in Thacker and.
I don't think you need to. I think you can save your time.
Okay. So I'll just jump right into it. Basically, the state has conceded the first prong of the Bruin analysis, which is that the Second Amendment covers the conduct at issue. So that leads us straight into the historical analysis, whether the state has met
I'm
its
going
burden.
to stop you and just ask a question here. There seems to be a question about who bears the burden here. Generally, when it's a constitutional question and a person is asserting that, as applied to them, a statute is unconstitutional, that person bears the burden of showing that it's unconstitutional. But under the Second Amendment jurisprudence, under Bruin and Rahimi, it talks about how the state bears the affirmative burden of showing that this restriction is within the historical tradition, et cetera, et cetera. So how do we solve that?
Well, so this case presents both facial and as-applied challenges. So with respect to the facial challenge, the state does carry the burden to provide a sufficient historical record for this court to review to determine whether our nation's history and traditions support the type of ban that's at issue in this case. And in our view, they haven't done that. With respect to the as-applied challenge, our duty is to just present this court with sufficient facts that explain why the law, as applied to our client, specific circumstances related to our client, render the law unconstitutional. But it
And in this
doesn't-
case, you're saying because your client is was 19 at the time?
18, now it's
18.
19, I think at the time this got litigated, but.
Okay, okay.
Yeah, so facially, all 18 to 20-year-olds, that is what we're attacking. But as applied to my client, and his particularized need for self-defense is the as-applied challenge in this case. And the factual circumstances where he was a recent victim of crime is where we met our burden with respect to the as-applied challenge. But in both situations, we're still relying on the state to carry their burden to show that the historical record justifies the regulation in this case, and it's our position that it doesn't.
So it seems like you're very clear that, and you want us to be very clear that for the second prong, it's that the state has the burden, and it's about looking at the historical analogs,
Correct.
but keeping in mind what Rahimi had taught us, right?
Correct, yes,
Okay,
yes.
so so this is what I find really interesting. So when I first, was reviewing everything at first blush of this case, in the past, we would look at what scrutiny is to be applied, right? And if we were looking at that, then it becomes really interesting as to why someone that is 21 and over is being treated differently than someone that's 18 to 21, okay?
Yes.
But now that we're not applying scrutiny, I don't know what to do with that.
Right.
Because it's all about historical analysis.
Correct, yes. And, what we do know is that there is some treatment in the law for people under the age of 21, but they were categorically determined to be minors or infants, as the state points out. That is remarkably different from an 18-year-old today, which is a lawful adult. And I think what Thacker teaches us is that we do need to start from the general premise of what does the Second Amendment actually protect? The people, and Mr. Whatley is definitely part of the people that the Second Amendment covers. So if he is a law-abiding citizen today, I think the more appropriate historical analog is what does the law, common law, say about treating similarly situated adults? Not necessarily minors, because we know that the law today doesn't support providing firearms to minors, but similarly situated adults. There's no historical support for treating Mr. Whatley
So what you're
differently.
asking us is to do away with the history of our nation, particularly at the founding, that someone under 21 had, some people might say no rights, but we'll say limited rights, And you're asking us to do away with that, basically, to look at it from the modern context of how we see an 18-year-old.
So we start with
Is
the
that
mod-
what you're saying?
Yeah, we start with the modern context, just like we started with the modern juvenile adjudication representation of juveniles who committed felonies with their adjudications, right? In that context, there weren't sufficient historical analogs because there was no juvenile adjudication. So an 18-year-old at common law wasn't an adult, but today they are. So I think we need to start from this fundamental premise that Mr. Watley is a lawful, law-abiding adult. So what does the history say about treating law-abiding adults differently?
And what's interesting, and I just want to ask you to help me with this,
Sure,
okay? I'm completely open here, all right? I come to these things completely open, right? The state is relying on different state laws throughout the United States that take place after the finding of our country, but that are very early
Yes.
within our nation. So is it your position that all of that is irrelevant?
It's not necessarily irrelevant. The Bruin and Rahimi courts kind of give us anywhere from the founding to Reconstruction amendments, but I think they are more closely aligned, looking more closely to the founding. So there is a temporal question there on how relevant they are. I don't think we completely cast them aside, but I don't think that they actually solve the question here today, because a lot of those laws that the state cites to do show some possession of firearms by the category that they think should be excluded.
Thank you so much. And then you use the term possession. So with this particular case, even as applied, your client has the right to possess a firearm. So the possession of the firearm was not the violation, it was the limitation on manner.
Yes,
So
correct.
not access, but manner. So what do you see as the overlay, if any, between access and manner?
So I think what's important to keep in mind here is the interplay between the concealed carry law and improper handling, and whether the concealed carry law burdens the right. And the state argues that because my client has the right to open carry, that his right is not burdened. But the improper handling statute shows that it was burdened, because if he wants to travel in a vehicle, he has to disassemble the firearm and render it inoperable, so he can't access it, which fundamentally reduces his right to protect himself within the vehicle as he's traveling.
You're not arguing that historically the right to have a firearm hasn't been burdened in some way, are you? Because, I was looking at some of the laws regarding prohibition of carrying a concealed weapon, and it seems like there is a history there that concealed carry can be prohibited.
Correct.
I mean, would you say that if the state said nobody could concealed carry, but they could open carry, would that be too much of a burden on the Second Amendment?
I believe the law currently reflects that as long as there is the inability to open carry, that generally concealed carry laws that limit that manner of carrying are presumptively constitutional.
Right, so, but that does burden people in some manner because they can't carry the gun the way they want.
Correct. So there has to be some justification. So there's two parts to Bruin in terms of how the right is being regulated, which is the manner-based restriction, and then the why. And when we get to we have to consider both. We can't just consider one and then carry the day. We have to consider both, right? So the why, I think, is really why we can look at these laws critically and ask ourselves, do they burden the right to bear arms in a way that's beyond just the presumption that these laws are constitutional?
But you're not, what I thought I heard you say is that if everyone were prohibited from concealed carry, there wouldn't be a problem. Your problem is that the 18 to 21-year-olds are prohibited from concealed carry.
Correct. I do want to be clear that is my sole focus today.
Right.
To the extent that I talk generally about concealed carry laws, I am only talking about
But isn't that more like an equal protection argument that you're advancing?
The equal protection concept does have some crossover in the Second Amendment analysis, because we know from the Rahimi and Bruin cases that there were certain classes of people that equal protection tells us today would not be could not be categorically precluded from carrying a firearm. That wouldn't make any sense. So there is some like crossover there, but this is still squarely within the Second Amendment framework.
Okay.
Because we're treating a class of, I mean, I understand the connection that you're trying to make to equal protection, but I still think that we're safely within the Second Amendment grounds, even though we're talking about a law that's presumptively constitutional. We can, it,
Oh, go on, finish your answer, and then I have a question when
What-
you're finished.
Yeah, what I wanted to get to is that, even if we can restrict certain groups under the concealed carry laws, there still needs to be some justification as to why this specific group, right? And that's kind of what we're here today as a counterpoint to the, okay, well, maybe if the regulation in theory is okay, it has to be comparably justified to this particular group. And that brings us to this dangerousness question that was introduced with the Rahimi analysis. In this court's discussion in Thacker and Brown, categorically, where is the justification that 18 to 20-year-olds are so presumptively dangerous that they should be disallowed from carrying a concealed weapon? There's no historical support for that.
So, Ms. Nelson, looking at the laws that were in place when the Second Amendment was enacted and when the 14th Amendment was enacted, I mean, there does seem to be some support for the state being able to regulate carry conceal. Do you agree with me?
I agree.
Okay. So does the fact that Ohio is a shall issue state rather than a may issue state, how does that work? I mean, how does that fit in?
So my understanding of Bruin on this issue is that when it comes to shall issue states, the criteria should be objective.
Okay.
And, age could be an objective criteria, but it's also ambiguously applied in this case, because why are we isolating 18 to 20-year-olds when 18 to 20-year-olds are adults just like their 21-year-old counterparts? That's, I think, why this particular restriction, while it's presumptively constitutional, it's one that definitely should receive judicial scrutiny because it's not a true objective marker. Like if we're categorically restricting all types of, I know that these particular issues are getting litigated left and right, but a particular type of felon, right? If we categorically restrict all of them because we presume that this particular category is all dangerous. With the adult context, we're isolating 18 to 20-year-olds as different from 21 and older, and there's no reason to treat similarly situated adults differently, especially if we're going to go down the road of whether or not they are more dangerous than their adult counterparts.
What would be the why on a state prohibiting concealed carry across the board? I mean, do we have historical analysis for that, of why states back in history or ever have restricted concealed carry? Like why is concealed carry a problem?
I'm not sure.
I mean, could it be that there's potentially, like, it's considered to be cowardly and dangerous, and you can surprise people by violence with your gun? I mean, something like that?
Perhaps, but
Because I question then, when we're looking at this age group, and you're asking about the why, and where do we find the why? Because I think that most of us, and this has been in case law, understand that young people's brains aren't developed yet, and that there's a level of impulsivity that young people have. So could that potentially be the why of why they carve out this particular age group and not being able to conceal carry?
well, we would have to look to how the framers considered that. So modern day crime statistics or, characterizations of this age group, I don't think are relevant as to what the framers were thinking in this specific age group as adults, why they should be treated differently. I appreciate your argument with respect to people who are not adults, true juveniles, true minors, but we're dealing with a class of people who are considered adults that are afforded a lot of responsibility under the law as soon as they turn 18. So I don't think there's a historical precedent to support the carve-out specifically in this case.
To support the why?
Yeah, exactly.
Attorney Nelson, give me one moment, okay? This is more for my peers than for you. So she's beyond time. I'm happy for her to continue on her primary argument if you like, and I can certainly give more time to the state. What do you prefer?
I'm fine.
You're fine with what?
Letting the
Or to
I don't have any
continue?
more questions for her.
Yeah.
You don't have any more questions? Okay, so, so then
If
I
I may
will.
briefly run into an additional minute, just to touch on the improper handling. They are related, but I think what's important to keep in mind about the improper handling is the balance between that and what Bruin and Rahimi have talked about with respect to the going armed laws. Going armed laws prohibited against going about the community and terrorizing other people, kind of going back to your concealed carry concern. But that wasn't at issue in this case. And, you know, to the extent that the improper handling prohibits doing that, they do that under the A subsection. Mr. Watley was convicted under the B subsection for simply having the weapon in the vehicle, which is only a crime because of his age. So because we think the minimum age requirement is an unconstitutional restriction on his right to carry a weapon, the improper handling should equally be found to be
So,
unconstitutional.
just so I'm clear, if somebody has a carry conceal license, either because they are a qualified adult or because they got the carry conceal license, then they can have a weapon in a vehicle on the
It's-
front seat next to them.
Correct, the fact of concealed carry ability is a defense to the improper handling
Okay,
statute.
thank you.
Thank
All
you.
right, thank you. Attorney Wessel, obviously, will we be liberal, okay?
Thank you,
Go ahead.
Your Honor, and may it please the court
No
and
worries.
opposing counsel. I wanted to maybe start by focusing, I think, some of what appellant's counsel focused on narrowing down what is actually at issue in this challenge. What I'm hearing from opposing counsel is they're not challenging whether or not it would be constitutional to prohibit concealed carry or improper handling. The only thing at issue is the state's use of age as a marker consistent with the traditions as they are related to the Second Amendment.
And the state is, are you conceding that this even violates the Second Amendment in a constitutionally relevant way? Are you conceding the first piece here?
I think that at least as this relates to the possession of a firearm in public, I mean, as I understand Bruin, the conduct is the thing that's in question. So at least to that extent, I do think that the fact that it was a concealed firearm, I do think is conduct protected under the Second Amendment. Whether or not the deeper question of whether or not someone is 18 to 20 is included within that framework of the people so as to meet the first prong, I would submit that I do think that those who are above the age of 18 are within. There's a broader question which I feel is also not being challenged here. It seems as though, and I don't want to put words in appellant's mouth, but it seems as though they're conceding that there is some age at which a person would be so young as to not be included as within the people as would have been understood. But I don't
And
think that's relevant
I just
here.
want to bring one thing that I'm struggling with this case, all right? Looking at case law, and there's one that's post-Bruin, and some of it is pre-Bruin, where age-related restrictions to firearms were being vetted out and constitutional challenges. There seemed to be developed the idea that the Second Amendment, that there was no infringement on the Second Amendment when it's an age-related restriction, which goes to the first prong of Bruin. So I found it interesting that you've conceded the first prong.
I think
So, and then, you know, but I can see the bleed over that nevertheless, that we have to deal with that, you know, we just wind up jumping over the first prong and getting to the second prong.
So there was a case, Laura versus the Commissioner of Pennsylvania in
Correct.
Pennsylvania. So
Correct.
that case went up to the U.S. Supreme Court and
Correct.
got sent back, and they actually affirmed their own decision recently in January of
Correct.
2013. And the big question in that case, because that case dealt with a categorical ban. I think what they decided is theirs was a may issue state. So in that case, the inability for a person under the age of 21 to possess a firearm was treated like a categorical ban. And the main question for the justices in that case were whether or not a person under the age of 21 fell within the people as is defined in the Second Amendment. Frankly, from my understanding of history and law, I do think that someone over the age of 18 would fall within the people as presumed to be protected. That does not mean just because they are protected that the inquiry ends. And I guess
So you're basically taking Blackstone and putting it aside then, in saying that?
I think
Because you start off your argument with Blackstone. That's the beginning of your argument, right?
So I want to be particular about my answer because this is a.
And I don't want to spend a lot of time on this, because
Well, I think-
at the end of the day, it still can fit into the second prong, the
I
same
thi-
sort of issues.
There has not been enough law for me to say definitively whether this question is more easily answered under the first or second prong. What I am confident, though, is that I think there's substantial evidence that, at least for the focus or the use of 18 to 20-year-olds, that the legal incapacity that existed at the time of the founding controls in the context of the Second Amendment. I think where the only thing being challenged is whether or not there is a historical tradition of treating someone who is under the age of 21 differently for the purpose of abrogating their Second Amendment rights. And frankly, that's all I'm hearing is being challenged. I think the law or the tradition that existed at the time of the founding absolutely supports that contention.
Well, and also, I think that the law, this is what's interesting, is that it's being framed on the differential treatment, right?
Right.
But when you look at the history and so on, under 21, regulation of firearms has already been deemed to be constitutional. So the question becomes, how do we put those two together? If
So-
already under 21 is constitutional, but here you're treating someone different, does that mean that this is constitutional per se? Or does that mean that there's still a constitutional issue that needs to be looked into, and that there's a valid constitutional challenge?
As I read Bruin, I don't know necessarily that I would describe it as constitutional per se, although I'm happy to give away the state's burden if that were the case. But I think one thing, what I take from the reading of Bruin, who in that case they examined concealed carry laws for a May issue state, and I think it was Justice Kavanaugh in his concurring opinion that stated that there's nothing in Bruin that should be stated to undermine the constitutionality of the shall issue states that, as opposing counsel referenced, objective standards. I think what opposing counsel referred to the state's law as that it wasn't a, quote, true objective marker. Certainly, I think age in this case is an objective marker. And as I read Bruin, and as I read Rahimi after it, I think the implication is that so long as there is an objective standards for the regulation of concealed carry, that concealed carry can be regulated. And they do go through and cite, and I have some with me if the court needs me to go through them, different states at the time of the founding that I think goes to what Judge Krause was saying, completely regulated concealed carry. And in those cases, and specifically the U.S. Supreme Court cited to a Georgia Supreme Court decision that made a specific distinction saying, we find it constitutional to the extent that the state of Georgia wants to completely outlaw secretly concealed weapons, so long as they allow for that option for open carrying. That to me implies that a state may regulate completely concealed carry. Then the question becomes, obviously I would think that if we could completely outlaw concealed carry, within that we would be allowed to further regulate it. And I think this goes to your question, so long as that determination is one that is supported by history. I do think that this is, I will share what opposing counsel said about this being somewhat related to a due process challenge, and it's sort of inherently entwined with Second Amendment analysis. But to the extent that the founding fathers and the ratifiers of the Second and 14th Amendment treated those under the age of 21 differently, I do think that can be sustained here. There was some question about why the founders did that. It's my understanding, and we kind of lay out in our brief, that those who were considered infants, I think is the term of art that is used, lacked, and I think this is maybe tied in somewhat to danger, but essentially infants were universally believed to lack the sort of rationality or capability that went along with the proper exercising of those rights. And that was reflected not only in Second Amendment jurisprudence, but in other types of the law. I think the phrasing from what I referenced in our memorandum is that those who were considered infants were one of the most, they had the most restrictions on the right of nearly any other class as we would consider them today, their rights.
To me, that makes more sense if we look at the fact that people under age 18 are not allowed to own or possess firearms. Because we have changed, I mean, if the age of majority back then was 21, the age of majority now is 18. And so I'm still having a hard time squaring this, your infant argument with our modern age of majority.
In terms of how,
The society has determined that once you turn 18, you are no longer an infant, versus back then, it was 21.
I would disagree that we determine someone just by the age of 18 that we're no longer able to regulate around their specific rights. For example, people under the age of 21 aren't able to consume alcohol. They're not able to to have tobacco products. That the reaching of the age of 18 under modern legal jurisprudence, I don't think changes our analysis on this question of, even though it may be 18 now, the question, as Judge Zeiss put it, is not, whether or not our current legal jurisprudence is controlling. As I read Bruin, the thing that controls is what we did in the past. So it may be the case that there's a good reason, a due process reason to treat 18-year-olds, that the state may not have a compelling interest in treating 18-year-olds like, someone who's of the age of 21. But where Bruin requires us to look back and use that founding jurisprudence, I do think that controls.
Okay, let me ask you a couple of questions related to that. Okay, so what you're saying is we are to look at the actual numbers rather than the age of majority.
Yes, I think, at least for the purposes of this challenge, I would think so.
Okay, so then we look to what was going on when the Second Amendment and the 14th Amendment were ratified, and 18-year-olds were required at the time of the founding of our country to serve in the militia and furnish their own weapons. There were several examples cited in the appellant's brief that talked about how people who were 18 in some places were required to possess guns if they were 18-year-old men, anyway. And then the service age for militia became 18 in every state right around the time that the Second Amendment passed. So if we're looking at a number, how can we ignore those things?
It's not that I would think you would ignore them. I think you have to place them in their proper context. In the Second Amendment context, I think one of the main holdings of D.C. v. Heller was that the use of a militia cannot be inherently tied in order to restrict or enlarge a Second Amendment right. What I would propose to this court is that I do not think a government forcing those under the age of 21 to hold weapons is the same as evidence of them being able to indicate their own right. In fact, I think the analogy I make in my memorandum is, if I tell my child, I want you have to sweep the house, they're not exercising their right to use a broom. They're being forced to do so. And in addition to that, at least 7 of the original colonies expressly in their statutes required parents to furnish firearms for those who are under the age of 21 to join the military. That, to me, implies that, at least as far as the Second Amendment can be understood within the common law right, that the control of the firearm is not given to the infant. It's on the person who is standing in loco parentis for them. I think I also make reference to collegiate rules. When you go to college, those colleges, and I think there was 4 of them around the time of the founding, completely outlawed firearms. And the implication there is those people who were under 21 who went to college, the colleges could completely abrogate their rights, which again supports this understanding that the person standing in loco parentis, whether it's the parent or the government, are the ones that are actually in control of those firearms. And I'll point out to the court that even though juvenile or those who are under the age of 18 were forced to join the militia, as of 1813, there was an act that was passed that's federally, that minors under 21 required parental consent to enlist in the Army. In fact, I was able to find a case called United States v. Anderson, which was decided by the Tennessee Supreme Court in 1812, so even before 1813, that would imply that if a parent wanted their child to be removed from service, they could do so. To quote from that case, "It is obvious that Congress did not intend the minor should have any discretion, either as to enlistment or discharge. The whole matter is entirely a concern of the guardian." I think so long as that malicious service was deemed in Heller to not be able to limit the Second Amendment right, I don't think it can be used to, the historical tradition of malicious service should be used to expand it. In other words, I don't think malicious service is inherently something that can be used in order to provide a understanding of how our Second Amendment works. At least that's my understanding of the Heller decision.
Going along with your logic here, would the state then be able to ban anyone under 21 from even possessing firearms and be in line with the Second Amendment due to this historical analysis?
If, under any circumstance, the question isn't posed here today. I think
But you're saying we have a history, right, of controlling anyone under 21's use of firearms, right?
is purely looking at a historical analysis of what existed at the time of the founding, I do think the ratifiers of the Constitution would have believed that it would have been permissible to completely ban those under the 21 from any possession of firearms.
Okay.
I do think that's what the history supports.
Okay.
I
Just
don't,
checking.
Right. I mean, I don't, obviously, that's not something that they did, but just because they didn't do it isn't necessarily evidence that they didn't believe it was constitutional. I think they had a lot of different considerations that they were dealing with at the time, including having to fight a war, raise militias that required them to, at least, I guess as they saw it, to bring them in. But to the extent that, at least for the majority of their history, the age of 21 was looked at as a legal age to reach legal personhood, relatively, I think the age of 18 is a fairly new concept, and certainly not what I think it controls in this circumstance.
So I have something that I want you to, I'd like your help in vetting out, okay?
To the best of my ability.
Okay. It seems that we're all in agreement that Bruin and Rahimi instructs us to look at historical analogs, okay? And the challenge here is the differential between the ages with regard to not access but manner, okay? And you rely on historical analogs with regard to those that are under 21. And within those historical analogs, there's discussions as to why people under 21 could be regulated, okay? So now we have science that tells us more about the development of the brain, okay? Which might justify the differential, but it's not part of our record. But it's interesting because had it been part of our record, can we even consider it? Because the challenge is all premised on the differential and the why of the differential, right? Well, the why of the differential is going to be limited to you get my point?
I think so.
It's all limited to historical analogs, not to anything modern that we can offer, such as the development of the brain.
I think, at least as I understand, and we maybe this hits more into due process territory, but at least as I understand it, the examination of why and the government's justification for a modern regulation, I think so long as it coincides with the laws that existed at the time, I'm not sure it's appropriate for this court to consider.
So what I'm trying to say is, like, even if there is a why, even if there's a clear articulated why, can we even consider it? Because that's going outside of the historical analogs, it seems to me.
I think courts are trying to determine that now, but just from reading Bruin, especially just reading Bruin, maybe it's a little bit different now with Rahimi focusing more on the principles. But I think a plain reading of Bruin would mean that it does not matter what the state's justification would be in a modern time, so long as there is a representative historical analog.
And that's where I'm at, because Rahimi talks about the principles, but is Rahimi talking about the principles on why we're doing what we're doing now, or the principles on what it is, on why we did what we did then?
I think at its strongest, Rahimi would suggest that we can do a in order to narrow our focus on the principles of the historical context, we can ask the government what their justification is for the current law. I guess in that context, a dangerousness determination.
So is whatever that justification is for our current law, does that have to line up with justifications in the history or not?
I don't know that it has to line up in a one-to-one way, but I do think that our justifications for treating those under the age of 21, because we believe that they're handling an inherently dangerous instrument and they are presumed to lack the capacity to properly exercise the control of that object, I do think that that lines up with the historical analog in this case. I don't know that I'm able to tell you specifically what the justices were thinking as to that particular question.
And I appreciate you doing the best that you can, and, as we all are here.
If I can just address one thing that was raised by appellant, there was reference to the Thacker decision, and I think, at least to the best of my ability understanding the argument, is that, well, in Thacker, we didn't treat the person, the focus of this court was on treating that person like an adult regardless of the age, and I don't know if that goes towards to what Judge Bach, what you were asking, but my understanding of this court's opinion in Thacker is there the justification for the court was the use of a criminal conviction like a felony conviction, and so in that sense, the justification inherently entwined the two. Here in this case, we're making specific reference to historical treatment of people specifically focusing on their age, not conduct becoming an adult or an infant at the time. So that I think is where this case, at least the state's justification here, is inherently different. Unless the court has any more particular questions, I have nothing further.
Thank you. I want to get clarity on one thing, okay? Bruin has a discussion with regard to concealed carry and open carry, basically, right? The laws, the historical analogs that appear to justify concealed carry for anyone being constitutional, is that something that we should be considering or not?
I believe the Bruin opinion said presumptively, which means they're still open to judicial scrutiny. I don't think that Bruin should be read to say all carried conceal laws are affirmatively constitutional, but they were careful to say we're not touching on the specific requirements under carried concealed weapons. We acknowledge that there is a history of carrying concealed laws, but they didn't even go down that road. So I don't think that foreclosed the arguments this morning, if that's what your question
Well,
is
I'm trying to
geared towards.
figure out, so if we treat it as presumptive, right, then how do we get over that presumption? Is it simply because of the age differential, or is there more to it than that?
Well, we get over the presumption by doing the Bruin and Rahimi analyses, right? The historical tradition has to support the age restriction, and as I articulated.
So it
in my
goes back to
opening-
the age?
Yeah,
Okay.
it goes back to the age.
All right.
Treating 18-year-olds as adults, not infants. On that point, I did cite a case from the District Court of Minnesota. Worth is in the title. That case has been decided now by the Eighth Circuit, and it was affirmed. And in that case, they found that there was no historical precedent for, at the district court level, which is the one that I cited, and the Eighth Circuit agreed, there is no common law understanding that 18 to 20-year-olds should be deprived of their firearms. Now, I believe that was an open carry question, but it does debunk a lot of the historical reliance that the state cites to today, like the schools, parents.
Wait, that was being deprived completely of the right to bear arms?
Yes, 18 to
Okay.
20-year-olds. But what the historical analysis, I think, is persuasive because it shows that there's always been a historical understanding that 18 to 20-year-olds, even if they were treated as minors, were having possession of firearms.
Right, possession.
Right, so
But
then-
restrictions we have in this case.
Correct.
And how does the history not demonstrate that because the age of 21 was the age of majority back then, why does history not demonstrate that there are concerns with the maturity of people under age 21?
Well, because I'm limited in time, I really want to redirect that question to the dangerousness analysis, which is what's presented by Rahimi. Because even if we get to this point where, okay, the law could be justified at a categorical basis, we still need to ask, well, is this category of people justifiably dangerous to prohibit? So it's kind of related.
But I thought, okay, then help me here. I thought this is, I mean, what the state's doing, they didn't really get into the dangerous analysis, this was more of a historical analog. They are showing that there are laws in history that demonstrate that as a society, we believe people under 21 were not mature enough to have full-on possession of firearms, right?
Well, I introduced the dangerousness analysis in my brief, and I believe the state did respond to it. And they sort of
Correct.
categorically say that 18 to 20-year-olds are presumptively dangerous, but there's no historical support for the dangerousness perspective. There's no statistical support for that. I think that was a question that Judge Zayas had, and I think that even if we go down that road, even if it were part of this record, it would be a slippery slope, because if we introduce statistics, crime statistics related to 18 to 20-year-olds.
I was looking at science. There's a lot of science now on the
Okay.
development of the brain.
Okay.
And that's been used in, in delinquency and all kinds of different actions.
Well, then
And
it's
determinations of policies that are, being changed by the legislatures throughout the United States.
Sure, but it certainly wouldn't be as applied to my client, who has no history of dangerous activity, no criminal history. The only thing that was preventing him from being a law-abiding adult, otherwise carrying a concealed weapon, was his age. So there's a couple of questions, if this court is curious about the aspect of the facial challenge, we do have open still the as-applied challenge, which in this case, the law, by operation of law, he wasn't allowed to carry a
Well,
weapon.
that's the only thing you're pursuing is an as-applied, is that correct?
No, we raised both facial and as applied, but I didn't have a chance to really hone in on, even if we think that this category of adults is presumptively dangerous, as applied to my client, he should have an opportunity under Rahimi to demonstrate to the court, the Rahimi analysis requires that the dangerousness be individualized, and that wasn't afforded to him under the operation of law, because it's a categorical ban. And Thacker and in this court's recent precedent, that's a problem. We're worried about, there's no support in this record for categorical dangerousness, one, but two, as applied to my client, one being the facial challenge, but two, as applied to my client. There certainly is none. And that's a concern in this case, and why it should be dismissed at minimum on the as-applied challenge. I know that I'm certainly out of time. If the court has any more questions.
Okay, I'll give you 30 seconds if there's something else you want to present us.
Nope, I just wanted to reiterate that the Minnesota recent precedent, it's clear that 18 to 20-year-olds did have access to firearms, and the lack of dangerousness with respect to that group on this record, should counsel in favor of.
You keep
Revenues.
saying access. Your client has access. Your
So
client
that's-
just can't conceal carry.
Correct, but
Yeah.
access to weapons, the fundamental part of the Second Amendment is self-defense. So I know we haven't spent a lot of time on the
We
improper
haven't spent any
handling.
time on self-defense.
Well, but that's part of the heart of all the Second Amendment cases.
So are
right?
you saying that concealed carry laws infringe on the ability to self-defense?
They did in this case, because of the improper handling implications. He has to disassemble his firearm, so he cannot use a firearm for his self-defense while he's traveling in a vehicle.
Okay,
And because
interesting.
we haven't spent any time on that, I will submit on my briefs with
Can I
respect to
just
that
ask a
issue.
quick question on that?
Certainly.
What about the gun rack in the vehicle? There's a rack option for transporting a firearm, right? In a motor vehicle. Closed package box or case, or in plain sight and secured in a rack or holder.
Is that the language under the B subsection? Because that's what my client was charged and convicted of.
Okay, so you're saying the subsection that your client was charged and convicted of doesn't allow him to carry a weapon in plain sight secured in a rack or holder?
I believe the B subsection is just,
That it has to be disassembled and in a
he
secure
can't have an
box?
operable firearm in his
Okay.
vicinity. It
Okay,
needs to be
I was just trying to understand that because I knew there was some sort of rack or holder thing in a or the transportation of a firearm, and I was just curious about that.
And admittedly, those are words that I don't understand.
Okay,
Not well-versed in all things firearm related.
Okay.
But I know that my client was charged in the B subsection,
Okay.
and that definitely has to do with the ready-at-hand situation.
Okay.
Which is why I wanted to introduce, the self-defense component, because it was infringed. If we consider both laws in conjunction, which is how they played out in this case, there are problems with respect to the right to self-defense under the Second Amendment. And I know I'm at my time. Thank you so much.
Thank you. Thank you both for your arguments this morning. We will take the matter into submission, issue a timely decision. We wish you a wonderful afternoon. Tyra V. Griffith. Okay, were you intending to argue this morning, or you're just here?
I'm here.
Okay, you can sit there if you like. I mean, you can sit here, yeah. All righty. And,
She just, the party just asked that you not sit there. I'm sorry. The party just asked that you not let her sit next to her.
oh, okay. You would prefer for her not to sit next to you? I'll be happy to honor that. Okay. And I just want to be clear, so Attorney DeSantis, you'll be the only one that will be arguing on behalf of the appellee, is that correct?
Yes, sir.
Okay, all righty. So Ms. Tyra, if you want to come up to the podium. Ms. Griffith, if you want to come up to the podium. How are you doing this morning?
I'm doing fine.
Okay, good. So let
And-
me just, and you may already know this, but let me just share a few things with you, okay?
Yes.
So you're going to have 15 minutes to present your case, okay? And you can take part of that time to then be able to respond after Attorney DeSantis presents for 15 minutes, okay? So let's say, for example, you take 5 of those minutes, that'll give you 10 minutes, and then later 5 minutes, okay?
Okay.
And as you saw, we may have some questions for you, we may not have any questions for you. We'll see how it all goes, right? Okay. So when I say, would you like to reserve time, that's what I'm asking you, if you want to set some aside.
Yes, that was my second sentence. Yes, I would like to reserve 5 minutes for
Okay.
rebuttal.
All right.
But
No-
thank you.
All right. So whenever you're ready, you go ahead and get started, okay?
And you're doing the timer, correct?
I'm doing the timer, but I'm not taxing you until you're ready.
It's okay, I'm ready.
Okay.
Thank you, Your Honors. Visiting students, good morning. May it please the court. My name is Julie Griffith. I am a pro se litigant on this appeal. As you mentioned, I like 5 minutes for a rebuttal. I'm appealing the decision of the lower court's order for parenting time. The grounds for my appeal, as you know in my brief, abuse of discretion, due process was denied, and the guardian ad litem failed to perform her duties. My motion to modify parenting time was dismissed by the trial court judge. And really, my biggest premise for this is that I'm not an attorney and I don't know all the rules, and to follow the very complicated argument that was before me, I didn't have a chance.
And just put that aside.
I didn't have
Don't
a
let
chance.
that
I didn't have a
affect you in any
chance
way.
to cross-examine in our hearing, but before that even happened, there were procedures of the court that didn't happen. We were told it was just going to be a trial court, a castle child motion, which I granted, I won that part. But we weren't told that it was going to cover parenting time, or that I was never told there was going to be a witness from the other side. I had a couple, I had a school witness, and as you can see, the judge did send out a very specific order, a scheduling order, saying, hey, listen, this is what you're going to cover. It's only trial court, or a castle child. And she also told us in the hearing prior to that the guardian ad litem and the parenting coordinator need not attend, because all we're talking about is a proposed castle child doctrine, if that would happen. So we go to court, And that morning, the guardian ad litem, I learned, was going to be giving testimony. And the judge also said in the transcript, on the record, oh, you were just told that you were going to be here to give testimony. Well, that's not fair to me. That's not fair to me. Like, I don't have any questions prepared for her. I have no idea what's going on. All I know is that it's a Castle Child trial, and the rules were changed the morning of the trial. So I attempted to cite some case law, which now looking at it, since this was filed, months ago, I would revisit that. I think it's very clear in the transcript, the intrusion and the lack of procedure for the judge. When I was not allowed to cross-examine father, she has been very protective in other hearings of him. When I want to say, well, look at this history of domestic violence, look at this prison sentence, and I just want to show the pattern of dishonesty and the false statements that led to those convictions. I just want to show that because the repeated domestic violence issues, the arrest in April 2022, those
Seems
are
to me
very
that you had some safety issues embedded in
sorry.
that too.
correct. And because there's 3 teenagers. One of them has aged out. My other 2 are 17 years old and almost 16 years old, much like the students in this courtroom right now, right? So
I'm trying to understand exactly what you were wanting to do that you weren't allowed to do, because I do know that the trial court did have evidence of the domestic violence record, right? Was there
Yes,
more, was there
but-
more with
yes,
regard to
but
that record?
I wasn't allowed just to ask a few things because kids were present in the most recent. They've been present on others. They've been present with father's second wife, some of which I've just learned in the last 2 or 3 years, unfortunately. But so I wasn't permitted to question. That's my thing.
You're permitted to question about the domestic violence, or was there other things that you wanted to ask?
About the domestic
We have
violence.
to look at how you're prejudiced here, and we have to look at whether the court already had the information of domestic violence in front of it sufficiently. So that's what I'm questioning, like what new you would have brought to the table through the questioning.
Quite honestly, he's never been questioned on the April 2022 incident. And that was pretty recent. And
Is
so
that the one involving his brother?
it was the girlfriend. They keep saying it's the brother. It was the girlfriend. There was a police report that was something my body camera, like direct quotes. It was a lot of blood and.
Well, the trial court did explain, though, that it reviewed the record on that case, right? So the trial court was aware of the details of that case.
My understanding is she was not. Like, she made remarks that she at first thought father lived in Illinois. Our very first meeting when she took the bench in January 2023, she mentioned, she's like, okay, so you're in Illinois. She's in Illinois. That's just where the incident. Like, I don't know what she actually knows. I don't know what she read. So when, for me,
Didn't she explain to you that she had reviewed the
she
record?
just said she knows everything. She said she read everything before taking the bench. And I questioned, one of my remarks was, okay, well then I had 2 protection orders with this same person. His second wife had a protection order all in Hamilton County, and I know she can see that, I believe. And she said yes. My issue and frustration is, well then why can't I ask a few questions? Because he lies about those stories. He will lie about those convictions. So then what's to say he doesn't lie about the question with the kids? Or what's to say he's not lying about some of the new incidents that took place in the last year? That was my frustration. Also, the whole prison thing was 10 years ago, but my understanding is when it's a conviction of dishonesty or false statements, that sticks with you. That, like, there are parts of his criminal history he cannot expunge. He cannot seal those because of the severity and of what happened. So,
Can I ask though, you're talking about wanting to have been able to explore the 2022 incident in more detail. Did you agree to reinstate his parenting time in October 2022?
It was
After the-
supervised visits. I did not. That was not, court ordered supervised visits, I want to say in November.
This was after that incident?
Yes.
What, you did not agree to it?
The court said supervised visits at a parenting center. Yeah, I do not recall agreeing to that. It was kind of forced. So,
Okay.
but that was not the same judge. That was the magistrate. Judge. It did not go to him. Okay. Hold on one second. Another ground for the appeal is the testimony given by the guardian ad litem was basically irrelevant because she testified and she cited the date of when she spoke with the school about my daughter who I was trying to get the Castle Child doctrine enacted. And the daughter was already 18 at that time. And there was a great deal of testimony all based on that isolated interview, which that was unnecessary. You know, I think there was a point right at the end of the testimony where when I questioned father, I was cross-examining him, and the judge intervened and said that has nothing to do with Castle Child. It did have to do with parenting. And I said, okay, I'm sorry. On the record you can read in the transcript, I apologize. But then 20, 30 minutes later, we're talking about parenting. So, which was not supposed to be discussed anyway. So how is there an order for parenting? How does that derive from the Castle Child? You know, and I probably erred and didn't state that correctly in my brief. And I look back and read it and I'm like, oh, anyway. So, but I'm probably ending a little soon.
You are, I'll carry over that time.
I have a question for
Sure.
you. So you're asserting that the trial court basically surprised you by entertaining the motions on parenting time, correct? Did you object?
I did not. I was close. No. I
Okay,
did
thank
not.
you.
I did not. And I understand too that in domestic relations, there's a lot of latitude for abuse of discretion, right? It's muddy. It's not, my perception is it's not as clear sometimes as criminal law or other areas of law. It gets trying to be a cluster, but there still needs to be parameter. There still needs to be procedure, maybe even more so when you have two pro se litigants. I didn't have an attorney because I couldn't afford it. And honestly, my kids are over 17 and almost 16, very independent kids. And in today's society, I'm not sure why I'm still having a guardian ad litem and a parenting coordinator try to tell us what to do, who haven't seen the kids anyway for several months, but not to get off on that.
So I'm going to reserve your time. Ms. Griffith, I'm going to ask you to stay at the podium for 1 second for me, okay?
I'm sorry, what'd you say?
I'm going to ask you to stay there for 1 moment.
Okay.
Okay. The GAS, is you? I ask you to sit in the back. You'll be able to see. You can go ahead and put this.
For these reasons, I asked the court to vacate the trial court's order for parenting time and order a new hearing for parenting time.
Okay, thank you.
If it pleases the court, on behalf of the appellee, Mr. Tyra, I've entered my limited appearance for the oral arguments. I did not prepare on his behalf. So my arguments today are, of course, limited to those presented by Mr. Tyra in his pro se brief. In doing so, I submit to you for consideration his response to the issues presented by the appellant, Ms. Griffith, and his argument for dismissal and sanctions set forth in his brief. Although a bit backward, I would first start with the end in mind to set the stage of what is critical for this court to be able to reference back to as we work through these issues. And I ask that you carefully consider this theme when rendering a decision. Next, I'll provide a brief response to the three assignments. Ms. Griffith asserts that there has been an abuse of discretion. Yet, as Mr. Tyra sets forth in his brief, this appeal exposes her abuse of the system and the injustice attempted on this court as all of the expenses, and also at the expenses of 3 children, 2 of which are minors. Pursuant to Rule 23, this court, sua sponte, may determine that an appeal is frivolous or prosecuted for delay, harassment, or any other improper purpose. Per the rule, Ms. Griffith's appeal shall be deemed frivolous if it is not reasonably well-grounded in fact, warranted by existing law, or supported by a good faith argument for the reversal of existing law. The court has been provided with a transcript of the docket and journal entries totaling 55 pages long. This record is replete with concerns of Ms. Griffith's abuse of the legal process, threats of court-appointed professionals, including filing frivolous civil lawsuits against them, complaints against lawyers,
Now, you're
GALs.
referring to it as frivolous suits. Has anything been deemed to be frivolous at this point?
Well, what happens is then she'll file these complaints, these attacks, and then or dismiss.
So nothing has been determined to be frivolous?
No, Your Honor.
Okay.
Slander and degradation against the court itself and every person that has touched or been involved in this case. Most
And again, you're
notable-
asserting slander and so on. Is there anything that's been determined to be such?
Not by our court, Your Honor. But I do believe that there is.
So you're asking us to, you're characterizing things in a way that have not been characterized, so we really cannot consider them under that characterization.
I'm limited to the, my client's brief, which did not cite case law. So that was the crux of his argument, was this slander and abuse of the process. So that, and I do believe that the record and the transcript also in the case does discuss those things.
Well, why don't you get to her main point is that she was taken a little bit off guard by what the hearing was about. There was a witness, the guardian ad litem testified she wasn't expecting. She wasn't allowed to explore the domestic violence allegations from 2022.
Yes, Your Honor. So first of all, this issue has been before the trial court 8 times since in between the dates of her filing her motion of May 9th, 2023 to this trial. At every step of the road and at every one of those court appearances, a parenting time was addressed. The appellant filed a motion for continuance on January 23rd, 2024, and the judge issued a decision via judicial review of that motion and sets forth in there that the hearing will also address father's continued parenting time. So she was aware of that, and I would argue to the court that she was aware of that because every single time that she was before the court, that was what the issue that was addressed.
So on the hearing that was scheduled for the trial on the Castle child motion, you said you believe that also said it was going to address the parenting time?
Yes, Your Honor. In quote, it says this hearing will also address father's continued parenting time, end quote.
And what was the date of that entry?
It was January 26, 2024.
Thank you.
As it pertains to her assignment of errors, as for the first one, in regards to the trial court erred and abused its discretion by dismissing mother's motion and modified parenting time. Although there's not any words in that portion of her brief to support that, however, I think it's important for the court to understand that motion to modify parenting time that the court dismissed and that she is basing her appeal was a parenting time of her requesting where the appellee had only 2 hours of parenting time per week, and she was asking that to be only 2 times a month, 48 hours a year. And the order that came out of the February 14th, 2023 hearing that was issued in the March 1st decision was only an increase of 1 hour. I think that's really important to put in perspective of what we're here on, is such a limitation of parenting time that was increased upon with active involvement of the GAL that was heavily involved speaking with the children up until recently where she's been denied access, but that that this is such a small amount of time for her to claim that she has not had appropriate due process or an opportunity to be heard, when in fact that she was notified that it was parenting time, not only by a litany amount of appearances before the court on that issue, just in between that motion, not let alone, the last 2 years, and that the fact that there's, the trial transcript in and of it's, not the trial transcript, but of the journal entries and the docket entries, exceed 55 pages over 14 years. This case has been heard. These matters have been presented over and over and over. And I think it's important for the court to know that when we're talking about her denial of being able to talk about a felony conviction, there is a date put to that. It was a tampering of evidence and a violation of protective order that occurred 12 years ago. So it has absolutely been before the court.
It seems that she's more concerned with the more recent incident.
The recent incident, which was of the 2022, which prompted the guardian ad litem interviewing the children, issuing 2 reports to the court, and a denial of supervised parenting time that the court, and that was in 2022, there was approximately 6 court appearances with between the parties and the guardian ad litem, and building upon that. And there was an agreed entry of October of 2022 that mother did enter into as it pertains to that.
She was arguing she wanted to bring out additional facts through cross-examination about this, and certainly domestic violence is relevant, right?
Absolutely, Your Honor, and I do believe that was the court did give her that opportunity. First of all, when she says that she was not able to call, was not notified of any witnesses. Well, Mr. Tyra didn't call any witnesses but himself.
I think she's talking about the GAL, right?
Yes, the GAL, which she has a right to be there, and she has been at all of them. Just because the court, says she didn't have to be, doesn't mean that, by actions of every.
She testified, right?
Yes, Your Honor.
Okay,
Yeah.
I think that's the issue.
Yes.
That
yes.
she wasn't expecting her to testify.
But she has been at every single appearance, though, for her to be there.
But
And-
going back to why couldn't she? Why was it not an abuse of discretion to allow her to explore the 2022 domestic violence on cross?
Because it was explored, and she did if you review the transcript, which I know you have, but that the court said if you want to cross-examine the GAL, you can do that now. If you have questions to her, you can do that now. If you want to present evidence, you can do that now. So that is absolutely on the transcript.
So you're saying that that's akin to cross-examination of your client?
Yeah, if
So it's examining the GAL and presenting independent evidence that is akin or makes the cross-examination of your client irrelevant?
No, I was respectfully.
And maybe I'm misunderstanding the issue, but that's what I'm understanding.
The question was about the GAL testifying. Is that, if I understand that correctly?
Well, no, you talked about that already. You said that she's always been there, and so it wasn't a surprise. But I think that I went back to the why she wasn't permitted to explore the 2022 domestic violence in more detail as she was trying to do.
Yes, and that was when that was presented towards the end of the hearing, that the judge said, if you want to ask the GAL questions about or present more information that's within the last 2 years, I've been fully informed of the 2022 protection order. I'm fully aware of it. And if there's anything else you want to present since then, I'm happy to hear it. And you can present that through the testimony of the GAL. And she also did cross-examine.
I guess
Sorry.
what this makes me think about is this. Can you point to any case law that justifies a litigant being denied the opportunity to cross-examination?
No, Your Honor. Respectfully, I didn't think that I was allowed to make any arguments outside of the brief and the limited appearance, because there wasn't any cited there. But no, I don't have any case law that can cite to that specifically.
Okay.
I would, if I knew that I would have been
Well,
able
but
to, I
that's,
would have.
that's sort of information in and of itself, because if that's the argument and there's no counter argument.
Well, the counter argument is that the court was aware of that, and the court did let her cross-examine father. Her argument was that she did not have an opportunity to cross-examine father, but she did. And just because the court said that, interjected, because the court has in her purview to control her courtroom, the decorum questioning, she, limited her in saying that they're being argumentative on the issues that she did cross-examine the father on. So that was my understanding of it.
Because you're saying that the court said that she had a lot of information about the 2022 incident.
Correct. And also, that was reflected in two GAL reports, specifically on the 2022 issue, that was copy and paste of the children's interviews, of the police record. That was, although not part of this record, it was in the hands of the judge, and who also said that she had thoroughly reviewed the record. So she was fully, completely aware of that incident. Let's see. And as it pertains to her, I think, does that, I think those the kind of the first and second assignment of error are kind of coincide. But the third assignment error, that the GAL failed to completely perform her duties pursuant to the Superintendent Rule 48, thus the court abuses discretion allowing her to submit testimony and suggest additional parenting time. In Ms. Griffith's direct testimony, she states that the reason for filing her motion for the casual child was that it was discussed by the GAL. So by mother's own testimony, she opened up the issues to the GAL's involvement with the adult child in her case in chief. And at no point during the hearing did Ms. Griffith object to Ms. Eckner's testifying in court. At no time did the appellant assert any objection to the testimony of the GAL regarding the witness, who was the subject of the first part of the hearing, which was an issue in which she prevailed.
So we have to review this for plain error because there was no objection?
She did not make one, Your Honor.
Okay. But our standard of review then is for plain error?
Yes, but my client didn't put that in his response, so I don't
But that
know.
doesn't change how
Our
we review
standard.
something.
Yeah, okay. Either way, a GAL advocating for the best interests of the children, providing information to the court of other persons whom the children live with, and most certainly their adult siblings, is always relevant. There is no error here. The GAL also reiterated that she has been part of this case since April of 2022 and has been informed of all the concerns. She acknowledged there being concerns of both parents, resulting in her requesting psychological evaluation. This was also acknowledged by the trial court. In sum, no error has been presented by this appellant other than her own error of perpetrating an abuse of this process. Because of this appeal, the lower court has issued a stay, and none of the PC
Oh,
orders.
let me stop you for a
I'm sorry.
second. So this appeal is strictly about the trial court's, I think it's March 1st, 2024 decision,
Yes, Your Honor.
correct?
Yes, Your Honor.
Okay, so I'm not understanding how that could possibly be an abusive process. Let me finish. The entry discussed, a change in parenting time. Why should she not be allowed to appeal that?
I'm not saying that she's not allowed to appeal.
Well, you called it, you said that her filings were frivolous.
Yes, Your Honor. It has been repeated delays. And
But we are strictly looking at this judicial entry and her appeal of it.
yes,
So what she has filed before that, that's not an issue here, correct?
that's correct. But I do want to bring the court aware, though, that there has been 9 PC decisions since then. The court won't hear any of them, and there have been objections filed to all but 6, and there is another appeal.
Are we allowed to consider that? I mean, that happened after this, correct? I mean, it's not part of our record.
Correct. But I do think that the record does reflect her vengeance against father and disrespect of the court orders.
But that doesn't really matter for this, for purposes of this appeal. Does that matter?
I think that the intentions of a mother as it relates to the children and the best interest of a child does matter, and the way that she goes about in the legal system, I think that is relevant for the court to consider.
Okay, thank you.
Do you have any other questions? I think I've said enough. Okay, thank you very much.
Okay, well, thank you for being
Thank you.
here. So you reserved 5 minutes.
Okay, thank you. So I'd like to respond to a few things that I've written down that counsel mentioned. In regarding to the December 19th, 2023 entry, this is what I was looking at, and I can hand this to you, or it doesn't really matter. I believe there was a second one. I'm not lying. I make mistakes and errors, but if there's one thing I am, it's honest. I wasn't permitted to inquire about a criminal endangering conviction to father that happened in 2022 in Hamilton County with a total stranger. It's not domestic violence, but it was another crime he pled guilty to. Basically was road rage. And that's something that I wanted to get in because that was recent. You know, the trial court judge was very adamant, like, I don't want to know things years ago. My thought was showing consistent, repetitive behavior, consistent history, that can be a danger with 3 kids. And my argument is not that I wasn't, oh, do you want to ask the GAL questions, the guardian ad litem? My argument was, well, I should have been told that she's going to be here. And to reiterate, the judge said, oh, Miss Eckner, I understand you were just told last minute, blah, blah, blah. Well, for me, that was, and I didn't object.
But is it not true that she has been at every other proceeding? I mean, how is this a surprise?
Most, because she's been there, but she doesn't always give testimony. So
Okay, but I'm just trying to understand
I think she was
your
gonna be-
error, because you said I wasn't told she was going to be there versus I wasn't aware she was going to give testimony.
I wanted her, I don't care if she was there for the Castle child, but then when the agenda of the court at the last minute changed as far as parenting, like, I didn't know it was parenting time. I didn't. And I
So
think,
you don't believe there's a court order that said parenting time on it?
Krista, can you wait until we change and then you'll, okay?
oh, I don't mind, it's just, I don't care. I was surprised when it was parenting.
Okay.
So, and when the
But
judge.
but the question is, was it on an order or not? And you're not sure if it was on or not?
I think it was on a January one. This is the one I've gone through, the first one.
But so I understand your issue with the GAL, because my understanding is the GAL has been at prior hearings. It's not so much.
But she doesn't always give testimony.
Well, then that's your issue, is that you were taken off guard that she was going to testify?
Right, and that's, like, we had to exchange witness lists. So if she was going to testify, shouldn't he have written her name on there? That's what's different about it. And yeah, I see what you're saying.
Right. I mean, and I'm just curious. I mean, the GAL is appointed by the court, so I would think the judge could have her testify.
But in my head, at the in-person hearing prior to this, December 19th, she said that the parenting coordinator and the GAL did not need to be there. So then when that changes, that's my question for fairness, you know. But for the GAL, I did not object. I think she made a statement that, did I object to her saying something? I didn't need her for the Castle child. All I needed was the school. Like, I subpoenaed a school witness that pretty much wrapped all of that up. The GAL, I think when there's all this mention of frivolous court filings, my basic thing is that the domestic relations court has not allowed some criminal stuff to come over. And so when a judge says, hey, I've already read this, I know it. Well, how do I know what you know? How do I know what you retain if I can't question and get that on the record? Like, I don't know. I honestly, I can look at the transcript, and she said, okay, this exhibit, this exhibit. They renumerated my exhibits. They moved them around, they changed, and that was my biggest thing. I didn't even know what you were going to be looking at other than the transcript, but the lettering was different. So that's not always clear for me either. And the judge's staff is very helpful, but I honestly, it was not clear what was going on. And again, I'm not an attorney, so I don't know to object. Some of this that I wrote to object to, it's because I had an attorney look at stuff. Someone, a friend, like, what do you think? And there were red flags for the person looking at it. 10 years ago, the same thing happened. I was pro se, property trial. I appealed, but I had an attorney, Jeffrey Rollman, presented, and I knew that case in and out, but I had no idea what was wrong or what happened. It was remanded back because the abuse of discretion was so big. I believe in this, it's worse. I believe there were things that should have happened quite differently, and I don't know, I believe even though you're not an attorney, you should be able to say, this was not handled correctly, something's wrong. And at the same time, I hate to take your time, and because of the level you are in the,
Well, that's what we're here for.
But the level of
I'm going to give you
expertise.
30 seconds to wrap up, okay?
okay. I think the filings, the frivolous filings, and she's alluding to things, because I have very openly made remarks that there's a conflict of interest. There was a lawsuit with the parenting coordinator, and she didn't pull off the case. This was in June of 2024. There have been a conflict of interest with Wagner and Block, with the judge, the guardian ad litem, the supervised, and I said that. And I don't know enough what I'm saying because I don't know law, but I know there's some things that aren't right. And that's what they're talking about with the frivolous filings. So, Your Honors, I really appreciate your time. I ask that you vacate this order. It goes back to the trial court. And thank you.
All right, well, thank you both for your arguments. Thank you both for being here. We will take the matter under submission and issue a timely decision. And we wish everybody a wonderful afternoon, okay?
Thank you very much.
So we're going to take a little pause. With regard to in re CR, you can come on forward and take a seat and everything, but I'm going to take a little pause before we get started, okay? Attorney Whitfield, how are you doing? You were doing good until a second ago, right? It's okay. When you're ready, if you can come on forward to the podium. Good morning again.
Good morning, Your Honors.
Would you like to reserve time?
Yes, 6 minutes.
Okay, 6 minutes. That gives you 9 minutes.
Thank
And you can start whenever you're ready.
May it please the court, opposing counsel, Mr. Berry. I'm here representing appellant Bethel Jones. He's father in this case. And I'm also a father. I started having kids way too early. But being a father didn't really affect me. But I became a dad when my daughter was 4. And being a dad saved my life. And so I actually have a strong understanding of why parental rights are so respected, rather so protected. And I understand why Mr. Jones, when I got involved with the case, he had already been fighting his battle for about a year or so, and has continued to do that for the last 3 or 4 years. Because he wants to be a dad to his son. He's a dad to his other children, and he wants to raise his son. He doesn't want to just see his son. He doesn't want to just visit with his son. He wants to raise his child.
So he has visitation.
He has visitation. It took him a while to get visitation. If you look at the history of this case, and we were actually before this court, I forget exactly when, but previously, he found out that he may have a child. He went. Eventually, paternity was established, but there was a large block of time between when he found out he may have a child and paternity was actually established, where he wasn't allowed to have parenting time with his child. So he missed a lot of his son's early life. And there was a delay there. Once paternity was established, he was able to eventually get some parenting time, which he's exercised consistently ever since. And primarily it's been without incident. There's no issues about his ability to care for his son, his ability to take care of his son, his interactions with his child's interactions with the rest of his family, with his other children, with the extended family. That's not an issue. I think that's important to note.
And I appreciate everything that you're stating, and I appreciate you sharing your personal perspective as well. As you know, that we are going to be confined to what the legislature has determined as to the different factors that the trial court would have considered, and the evidence that the trial court would have weighed in considering those factors,
Yes,
right? And I know that there are 2 assignment of errors that are lodged here. So can you please, share your arguments with regard to that?
So we believe that the court abuses discretion in reaching its decision, finding that father is unsuitable. And they found that particularly with saying that it would be detrimental to the child if he was awarded custody. Abuse of discretion means that there's an unreasonable, arbitrary, or unconscionable decision. And a trial court's decisions that's not supported by competent and credible evidence can be deemed unreasonable, and it should be reversed, and that's what took place here.
What were the reasons why the court found him to be unsuitable that you disagree with?
Basically, the magistrate's decision, I think, listed 4 or 5 so-called facts, and we disagree with all those facts, Your Honor. Mother in this case came and testified that father provided her with drugs and her friends with drugs, and this was in her home, in his home, for over a period of a month or so. The magistrate found that credible. She found that compelling. She used that in part to find that Mr. Jones was unfit. If you look at the transcripts, review the transcripts, mother testified to this fact. She didn't state that she hadn't been in father's home for 4 to 5 years. She went on to state that she's never seen father touch alcohol or use any drugs of any sort. Those are the kind of factors that the court just ignores. That father he's been sober for over 20 years. He was forthcoming throughout his testimony. The transcripts reveal that. He's never hid anything. But the magistrate decided that mother was credible. Even though mother testified in this particular hearing that she told her parents and everyone from the court and everyone else that Mr. Jones was the father at the very beginning. But if you review the whole record, that's simply not the case. That's simply not what happened.
So what is our standard? So one of your issues is the credibility finding mother's testimony to be credible?
That was one of the factors that the magistrate looked at, the court below.
But how do we, as an appellate court, I mean, we weren't there, we didn't hear the testimony, how do we handle this credibility determination?
I don't think you have to manage the credibility determination, but part of what the court did, the court made great efforts to find Mr. Jones unsuitable. And so they heard this testimony from mother, and they grasped at that. Because throughout the 3 or 4 years of the case, you never heard anything about drugs in father's home, alcohol in father's home. That was never mentioned or brought up by anyone.
It seemed like a big issue in this case had to do with surgery that was needed for this child.
Correct.
It seemed to kind of
took
dominate
over,
the
right.
proceedings.
I would agree. That was the second factor, I think, that the magistrate put in her decision, that she said it was actually detrimental to the child. Mr. Jones wanted to get second, maybe a third opinion.
I thought it was like a fifth opinion. I thought that there were already 3 opinions, that
think
he
she
needed to
said-
have this surgery.
There were, I don't know if there were 3 opinions at the time of
There
trial.
were at least 2.
There were at least 2. And then my client found out about the pending surgery. He asked me to file a motion. We filed a motion to try to get some clarity, not necessarily to stop it, but to give some clarity. And if he could, he wanted to stop it because he wanted to find out what was going on.
But didn't several doctors opine that delaying the surgery could cost the child his eyesight?
I heard that testimony, but I haven't seen any of those documents. There are 2 exhibits submitted by the grandparents where the doctors recommend the surgery. But if the surgery didn't take place, if the surgery didn't occur, that's not Mr. Jones' fault. Because at the time, Mr. Jones didn't have custody. At the time that this diagnosis was made, the grandparents had custody for, I think, 2.5, maybe 3 years. So if the child needed the surgery immediately, then surgery could have taken place.
Well, okay, but let me back up for a second. Regardless of whether the surgery took place or not, could the trial court not have considered the fact that your client wanted to delay the surgery as an indication to his suitability?
I don't think they could have, because he's a parent. So surgery is obviously a major event in any person's life, and you have to consider that. And the exhibits from the doctors say at any time you have surgery, you have to consider the risk, which is all Mr. Jones did, was consider the risk. And he wanted to get an opinion. He wanted to talk to another expert, an additional expert. I don't think that goes to his unsuitability. I think that goes to his parenting ability. He wants to make sure his son needs that surgery. The child had been diagnosed. The child had to wear a patch. The child had to do certain things to try to alleviate the issue.
And the medical experts that we do have information from were saying that the child could lose their eye, right, if they don't get the surgery.
I think they said that was a possibility. I don't remember. I haven't seen anything from the medical doctors that said that, but I believe I heard testimony to that effect.
So it seems like the surgery was a major issue.
The surgery
like
became a major issue.
considered to be a necessity for this child. And I think the magistrate was very concerned that
was
your
very
client
concerned.
was going to prevent that from happening.
And that's the thing, my client couldn't prevent that from happening. If the surgery needed to take place, the individuals with custody could have made that happen. She expressed that they had concerns about it, so they delayed the process. The custodians delayed the process. My client didn't delay the process. He had concerns about that surgery taking place. The surgery has taken place now at this point, so the child is well. But I was starting to say, even before the surgery occurred, there were certain things that all the adults had to do to make sure that the child was getting, the treatment he needed. At no point in time did Mr. Jones not provide the treatment that he needed. Did he not stop? Did he prevent his son from wearing a patch? Or did he diminish the fact that his son had a condition? All he wanted to do was make sure his son needed that procedure done. That's not unsuitable, in my opinion. I think that's what a parent is supposed to do. The third thing that the magistrate talked about, and she kind of flip-flopped on this, she said that Mr. Jones works long hours. And he doesn't really have a lot of help with his child. Well, he works long hours because he's under a support order, which again, the magistrate and counsel made a big deal about. They said, oh, he's got all these arrearages. He's got $24,000 worth of arrearages. When child support was set up, originally, the order immediately put him approximately $17,000 to $18,000 in a hole because they took the order back to the date of the child's birth. Before paternity was established, and that's a different issue. I don't think it's proper, but it's a different issue. Nonetheless, my client was immediately in a hole, $17,000 to $18,000. 4 months later, he's fighting contempt of court. for non-payment of support. But it's not mentioned anywhere in the decision that he's paid $16,000 to $18,000 in child support since this order went into effect. That's not mentioned. So again, he's financially taking care of his child. He's spending time with his child. He's parenting his child the best that he can under a limited order because he only sees his child he sees him weekly for maybe a day and a half total. But that's not enough time to parent his child. But he's doing everything that he can do. The magistrate went on to say she was concerned about Cameron had the eye problem and father discussed football and boxing. And so the magistrate ran with that. Oh, he wants to put the child in boxing. He wants the child to play football. Because he's a parent and he has a son that he may want to play sports when he grows up. I don't think that's unsuitable. I think that's what a lot of fathers do. I think that happens a lot. My father wanted me to play sports. I don't think that made my dad wrong. I had asthma. Play football in the grass. I'm allergic to grass. But my dad wasn't unsuitable because he wanted me to play sports. Mr. Jones wasn't unsuitable because he wants his son to be active. He testified that his son is already active. His son's jumping around, having fun when they interact.
I'll give you just 30 seconds.
Yes, ma'am.
Okay.
I'm still answering the first question. The magistrate also talked about father's excessive history of domestic violence. She talked about a conviction, I think, from 2003, violation of protection order, this alleged history of domestic violence, and this child support order, as she also referenced, a prior child support order stemmed from a divorce. that
Basically,
happened.
you're saying that there wasn't really relevance to that.
It wasn't really relevant. It was over maybe 20 years old. And you start looking at this record, 20 years before the child was born, 20 years before the child was conceived. And as I indicated before, that's because the court went to great lengths to find something to make this man unsuitable. But when you look at the real evidence, the relevant evidence, the credible evidence, the preponderance of evidence, which the court is supposed to look at, the evidence indicates that he's responsible, he's employed, he has housing, he's nurturing.
Can you address the court's finding about his girlfriend who was in sober living?
So Mr. Jones testified, well, I think it may have came up initially.
He testified about that
He
apparently.
testified about it. I think in one of the visits, or maybe there were two visits at least, exchanges, I'll say. A friend, I don't know if it was a girlfriend or not, but a friend of Mr. Jones was present at the exchange. And I think either grandfather may have had an issue with this lady, said she looked like she was drunk, under influence, and then mother came in and testified and said, I know her, she uses, I used to be in sober living with her, or something to that effect.
The magistrate found that he admitted his girlfriend was in sober living, and he did bring her to a visit, and she spends the night with him when the child is not there.
Right,
Okay.
correct.
And so this was another concern that the magistrate had about the child potentially being exposed to drugs in some fashion.
If that's the stretch she wanted to take. but-
That is, yeah,
Yeah.
clearly.
And Mr. Jones, again, he was forthcoming with everything. So he didn't deny that he knew this young lady. He didn't deny that she had issues with drugs, just similar to like mother did. But he was forthcoming when he said she's not around the child. He takes care of the child. And that's why I said on one side she says, well, father says he has nobody to help. But then on the other side she says, well, what if this person is present? And mom even testified to that effect. And I know I'm over. So
Okay,
I'll
so I'm gonna,
sit down for a moment.
because I'm sure you want me to reserve your time.
Yes, ma'am.
Okay, thank you.
Morning.
Good morning, how are you doing?
Just fine.
All right, you can start when you're ready.
May it please the court, Brad Berry on behalf of Appellee Renfro's. The issue here before the court, I believe there's two issues. The first one is, did the court cite to credible evidence to justify that the custody to father would be detrimental, unsuitable and detrimental? And I would say absolutely yes. There was evidence, I'll talk about the child first. And this 3.5-year-old child was the second time that we were at trial. And he had his share of medical issues in his life. And for the prior 12 months before we went to court, for the second trial, he had been diagnosed with amblyopia. which was a severe case of the crossing of his eyes, the weakening of the muscle, and one of the exhibits, or a couple of the exhibits, showed that this boy's eyes were getting worse. He went to his pediatrician. The pediatrician acknowledged it and did issue eye patches and attempt to do pre-surgical solutions, and those didn't work. He went to 2 different board-certified ophthalmologists, the first one being at Children's Hospital, where he recommended the surgery. When Father found out that there was scheduled surgery, Father filed an emergency motion to try to stop the surgery. And in abundance
Was it to stop the surgery, or was it to gain an additional opinion or additional insight from a medical physician?
well, the motion says to stop the surgery.
Right, but what was
Right.
the underlying basis?
Well, Father testified that he wanted to seek a second opinion, but during the trial, what Father did between
So in
July,
order to seek a second opinion, then the surgery needs to
Father never,
be paused, does it not?
yes, it
Okay.
does. Father filed that motion, I believe, 7 months prior to the trial taking place. And at trial, Father was asked, have you sought a second opinion in 7 months? And his response was, well, I wanted to look at a lawyer in Cleveland, but I haven't done that yet. This was an emergency situation where the child's health was at risk.
Well, I don't know that the record reflects that it was
Well-
an emergency situation.
Okay? Fair. I do believe that it was an urgent situation, that the second board-certified ophthalmologist, Dr. Coyne, was scheduled at the request of Father on behalf of so the custodian scheduled it. Father appeared at that, after he had filed the motion, Father said, the custodian said, let's get your second opinion. So we went to a second board-certified ophthalmologist and made sure that Father could be present. Father appeared at this scheduled appointment an hour and a half late. And then, after the ophthalmologist stated in front of him, we recommend this surgery occur immediately, Father proceeded to argue with the ophthalmologist and said, I'm going to get this stopped. I'm going to get this stopped at court. This is a
Is
waste.
that part of our record?
It is part of the record. It's referenced in my brief and referenced in the transcript.
I understand this eye surgery was a major focus
It was.
of the proceedings below and the magistrate. And so basically, based on the father's actions in this case, the magistrate extrapolated that he's not going to provide this child with future medical care, right? I mean, that's what we're to read into this,
With-
that the concern that because he doesn't want to do this eye surgery or he wanted a second opinion, the child's not going to get properly taken care of later medically.
With necessary medical care, with recommended medical care,
And how do we make that leap?
that it was recommended or that.
No, I mean, this is a kind of a unique situation where the dad was questioning whether to give surgery on this child. How do we make the leap that he is going to deny this child in the future necessary medical care?
I believe that the evidence is in the transcript, and it's also cited by the magistrate, that the magistrate said that Father had time to get his fourth opinion and had not done so as of the date of the trial. That 7 months had gone by since the first recommendation. 3 months had gone by since he had met with the second ophthalmologist, and he still hadn't obtained what he was saying, the reason why he wasn't going to have the surgery is because he wanted to get at least one, maybe two more recommendations or opinions before this child had this surgery.
So we could just presume that he's not going to properly take care of the child for any kind of necessary medical procedure in the future?
He had not taken any action prior to the court date to act on why he was saying he wanted, and nobody was prohibiting him from doing that.
See, what I find interesting about the record is there's obviously more than one way to read it, but that's in every case. The necessity, this term necessary surgery, while there is a discussion of the potential risks of not having the surgery, it didn't seem that that discussion was heightened to the point that there was a high probability that that would occur. And the record also speaks to the risks of the surgery itself, okay?
That is correct, Your Honor. And
So,
I
so,
believe the
so
doc-
looking at all of that together and then going back to the inferential leap, it kind of undermines that inferential leap. Would you agree with that?
I would agree that yes, he did not have the ability to do the surgery. He wasn't the custodian at the time.
And then,
Yes,
and that was the, yeah.
there is an inference
Yeah.
that.
So what I also find interesting about this case is in reading the order, it appears, because of the length of discussion in the order, that there was quite a bit of emphasis with regard to this eye procedure, okay?
There was some emphasis on that.
Right. But there's also a discussion with regard to the current girlfriend.
There was
Right.
some by
Right.
several different witnesses.
So what's interesting about these cases when they come to us is, even if there was error as to one, if there has to be error as to both in order to justify a reversal, for us to be able to reverse. So you get what I'm trying to say
I
here.
understand what you're saying.
So maybe you need to talk about the girlfriend thing.
I'm happy to,
Okay.
because there are multiple witnesses that testified with regard to that. First was mother, who entered an appearance in the trial and provided testimony with regard to her relationship with father. And she testified that father was providing her drugs in the very apartment that he continued to reside in, crack and fentanyl. And her concern was that that crack and fentanyl was still in his residence.
Because it seemed like there was a credibility determination that was made by the trial court, right?
She had been clean and sober for several months. Yes, I would agree with that.
Yeah, there seemed to be a credibility determination there as to, that then went to the weight that was, whether this was considered to be
Absolutely.
evidence of detriment.
She very honestly testified as to her drug issues. She testified to living in a sober home. Mother testified to living and knowing father's current girlfriend. And while they were at the residence, she was kicked out of the sober living for drug abuse. She was concerned that her child was going to be living in or staying at the same residence where this woman was admittedly going to and staying with father for periods of time, and that she was still using drugs, and that even a slight hint of this crack or fentanyl that's left in that residence could be extremely dangerous and a bad situation for this 3.5-year-old child.
Can you help me with the record, though? Did mother because opposing counsel here to you just said that father has been sober.
Yes, father.
So is there was
evidence
no evidence that father was using drugs,
No.
that mother was concerned that father was using drugs?
No.
The concern here was that because his girlfriend was kicked out of sober living and might be using drugs, that there would be drugs and lived with him occasionally, there would be drugs in the apartment.
Father testified that he gave money to these women and that these women would buy drugs. He didn't use the drugs, but the drugs were being consumed at his apartment.
Mother testified he sold the drugs.
Mother testified he gave him the drugs.
That he gave the drugs, okay,
He testified that I gave her money and she bought drugs with them.
okay.
But the drugs were there. He didn't say he was using them. The women were using the
Right,
drugs.
so there's no concern about father's sobriety in
Not
this
about,
case?
the issue was not father's sobriety here. The issues were the drugs and what was taking place in the apartment. And the testimony was that this child is being accompanied. Father was had this woman accompany him during his visits, during the exchanges, and father testified that this woman was in his apartment. And I think that's what the court picked up on as a concern and a risk for this child.
Because what was before the court was custody of the child, not visitation.
Correct? Correct. There are
Is
other.
the child allowed to visit under the visitation order? Is the child allowed to go to father's apartment?
Right, currently there is a visitation order.
So that concern is still there with his visitation.
It is a concern, right? And the visits for many months were supervised. They were at a library for many months. And
But it seems like the court believed that when the child was visiting father, that the girlfriend was not present. It seems as if
I would tend to agree with you.
that was weighed credibly
Right.
for visitation purposes. And I think the
Correct.
difference is custody, then a young child would be there with father presumably all the time except for any times of daycare.
Yes, I agree with you, Your Honor. And I also believe that the court was looking at parental decision-making and whether his decision-making was unsuitable and detrimental to the child, and looking at the global picture of medical decisions, making the decisions to who he is accompanying with the child. He's driving with a 3-year-old on his lap
That was across the parking lot,
in a
right?
parking lot, correct? Gosh, again, opposing counsel brought this issue up about the football and the boxing, and I understand there's lots of dispute as football and boxing, whether it's appropriate for a healthy individual.
Yeah, and at the end of the day, it was unsuitability and detriment, which is, it's not a
It's not a small thing.
It's not, exactly.
It's not.
And it goes back to counsel's argument about parental rights.
Correct.
This is all rooted in what's been deemed to be a constitutional right.
Correct. I honestly believe the largest issue here is the medical issue, but there's also major concerns about the drugs and the testimony from about the girlfriend and about testimony from mother, and the party seeing this woman, literally seeing her at the exchange with this child. With regard to the second part of the appeal, and I believe it was an issue regarding parenting time and not meeting the standard order, I believe it's well within the court's discretion, and in fact, the court must look at the best interest factors when determining parenting time. The court spent multiple pages and reviewed all of the best interest factors in its decision. I think it was weighted pretty heavily on best interest. I won't take a lot of
And
the
at the
court's
end of the
time
day,
on-
he has unsupervised visitation, does he not?
He is performing unsupervised visitation.
Okay.
Yes, limited. I believe that the magistrate was correct in awarding some visitation and appropriately assessed mother's current sobriety and was awarding her some parenting time as well. But for the reasons under Perellas, under I believe it's HJH, and why this matter was sent back to the court was for one purpose, and that was to determine whether it would be detrimental for this child. And that's why the court was really listening to the evidence and really listening to the testimony, really reviewed the medical evidence from both physicians, from the primary care physician and one of the two board-certified ophthalmologists. The other one, we had testimony from both parties, and it was undisputed. Father also agreed. I disagreed with the board-certified ophthalmologist at his second, the one that was scheduled specifically for him. He didn't deny he argued with this
And it seems
ophthalmologist.
as if the court in some way is acknowledging that all the family members involved here truly love this child and want what's best for the child and bring value into the child's life, because nobody has been barred from being able to be engaged with this child.
Always a blessing when multiple people are involved in a child's life.
Are you confident that the juvenile court judge did an independent review of the magistrate's decision in this case?
Interesting.
'Cause
Yes,
I saw an abuse of discretion discussed in her order, so I was wondering what you thought.
right. We made pretty long arguments in front of her, oral arguments. I do believe that she did.
Because was there an issue of some missing transcript that came after her
There was.
decision? Like, what was the deal with that?
Yeah, there was, the trial was recorded. The video came through, the audio, and a small portion of the trial did not come through for whatever reason. There was a technical issue with half of one of the witnesses' testimony. And counsel and I prepared an agreed entry to cure that defect, and agreed that we would acknowledge the fact that we would use the magistrate's decision as the formal record for the purposes of appeal. That was filed and it was adopted by the court prior to the appeal.
So piggybacking on that, though, in the judicial entry, the juvenile judge said that she had reviewed all of the necessary transcripts, is what she said, and did not acknowledge the fact that there was this issue with the transcript, and that, part of the proceedings simply weren't present, and
Right.
that there was that entry. And didn't the entry, though, come after the trial court's, the entry accepting that agreement, didn't that come after the trial court's decision?
No, it came after the magistrate's decision and before the judge heard it. The judge saw that we adopted the magistrate's decision to cure the record. The judge would not hear this until we cured it. And so, yes.
Is that in the record?
Yes, it was continued to cure the record. And there is an entry, I don't have it in front of me, but there is an entry from the judge continuing the matter until it was cured, and then acknowledging that it was cured.
Was there a transcript with regard to the discussion of the
Yes.
curing of the record, and that's part of our record?
Yes, it is, Your Honor. So to answer your question, the judge did have the full record with being the magistrate's decision, which was, we agreed that would cure the record at the time that she heard the argument.
So you are satisfied that she did an independent review of the magistrate decision?
I am.
Okay.
And just bringing, you might be aware of this, that's been an issue that has come before this court, and we have remanded because of the language in the entry, and the importance of the court using the right lens in
Yes.
looking at, the facts and so on, and into making its determination. So,
Yes.
yeah, so you're aware
We
that
were
that
very
is an
aware of
issue.
that to make sure that we were drafting that, to put it together, to make sure that we weren't spinning our wheel. Counsel and I were creating the correct record.
Great.
All right.
Thank you.
Thank you. Thank you so much. All right.
Just a couple of points.
I'm going to, I apologize. I wasn't aware that there was going to be this in the middle of arguments. I thought that would be at pauses.
No problem.
All right.
I think one of the questions that the court may have had takes me all the way back to the very beginning of this. And I heard Attorney Berry said a couple of times that there was a time frame after my client filed his motion to stop this procedure, allegedly to stop this procedure, 7 to 8 months before we had trial. And the question, why didn't Mr. Jones get a second or third or fourth or fifth opinion, whatever number it was at that point? And again, that goes back to his inability to parent his child. He didn't have access to his child to get.
And is that, did he establish that as a basis as to why that opinion, that additional medical opinion did not take place during the course of the time period?
I mean, he gets his son on Saturday afternoons and returns his son Monday morning. So I'm not sure when he was supposed to make an appointment. He did not have the ability to make an appointment to get additional.
So what you're saying is that your client established on the record that he attempted to get this further opinion outside of his parenting time, and it was not permitted?
He would have to have his child. He would have to have
I understand that part. What I'm saying is, even if he only has him for Saturday, Sunday, for the weekend, did he take any steps to try to get this additional opinion outside of his parenting time?
He did.
And is that on the record?
I don't think he testified.
Something we can consider.
Well, it's on the record that he didn't have access to his child except for very limited periods of time. And because of that limitation in time, it was difficult for him to get this other opinion that I heard Attorney Berry kind of say he should have got. So I wanted to touch on that. I also wanted to touch on the fact that
Well, it sounds like you're also saying that it was an abuse of discretion for the trial court to tax him for not doing it within, if they taxed him for not doing it within a certain period of time.
the decision made it clear. The decision states that father's actions have already been a detriment to the child. That's what the opinion states. That's improper. That's incorrect. Factually and legally, that's not a proper statement. And then to go on and say to give him custody would be detrimental, again, that's an abuse right here. That's an abuse of the discretion. The court is tasked, and the suitability is supposed to be determined.
And I want to go to Judge Krause's question, and I'm not sure that, if you haven't had the opportunity to consider it, that's a fair answer, okay?
Yes, ma'am.
On the language of the trial court's determination in reviewing the case under objections, it doesn't appear that the right standard of review is applied because there's not an articulation of the correct standard of review. Do you have an opinion with regard to that?
Not that in particular.
Okay.
Again, I would reiterate that I believe that the court went to great lengths to make an unsuitability finding in this particular case. And this court has issued opinions in the past. Suitability is supposed to be determined in terms of the child and not a judgment on the parent, him or herself. It's about, is this parent suitable at this time, the time we have this trial? And so this court and this decision relied on a whole bunch of historical things that I believe were irrelevant. Then they relied on some new information. The credibility is, in my opinion, questionable. And they ignored the testimony from my client who refuted all these allegations. He testified that he gave mom money because she would ask money for cigarettes, and then she would go out and do whatever she was going to do with this money. He wanted me to point out, and I forgot, we talked about this girlfriend that became an issue. His girlfriend is currently a peer support person at the Cat House. When he started dating her, she was in sober living. Mr. Jones is in that world. I won't talk about it. That's not in the record. But Mr. Jones met her through sober living. So he doesn't have any issues worried about her drug use, and she's limited around his son. But the issue here again is that the court did not consider all the evidence that was available. They did not properly analyze the actual facts of this case. Because again, if you look at the facts of this case, what you have is a man who wants to parent his child. And to the second point, because I just failed to address it, he's been given limited parenting time. He's very much below the standard order from our court, which almost is, I think it's 50-50. I'm not sure if his son is at that age yet or not. But at some point, he will be at the age where he should be getting, and I say 50-50 because I usually split it between the parents. And to say that Mr. Jones is substandard some kind of way, that he gets a little bit more time than mom gets. And mom has a history of drug use. Mom has been absent for much of this case. But Mr. Jones is somehow put at the same exact level as mom, in my opinion, because the parenting time that he has is very, very limited. And again, he can't raise his son by seeing him on Saturday afternoon and hanging out till Monday morning and getting holidays. He exercises that time religiously.
And that's what the parenting time is right now.
That's what the parenting time is right now. That's what the parenting time is ordered. He gets all his time He asked for additional time, and I think to the custodian's point or credit, they've allowed him additional time, occasionally here and there. Nonetheless, he should not be restricted with the son. He should have custody of his son. He's not unsuitable. When you look at the statute, when you look at code, when you look at the burden that the custodians had in this case, they did not prove that he's unsuitable, that he's unfit in any way. All these issues, all these facts that came up during the trial, because during the trial is when the issue with the eye came up. The visit or the exchange when they saw the girlfriend, that was after he was exercising his parenting time. The parking lot incident when he had his son on his lap to drive from here to there, that was during an exchange.
I'll
When
give
he's
you 30
returning the
seconds to
children.
wrap up, okay?
So, Your Honor, we'd ask the court to reverse the decision, remand the decision's improper, it's against the law. My client is not unfit, he's not unsuitable, he has a constitutional right to raise his children, that's what he's asking the court to render today. Thank you.
Thank you. Thank you both for your arguments this morning. Thank you for the parties for being here, because it really exhibits the love and concern that you have for this young child. I commend both of you, because it's very clear that you really do love this child and are really doing the best that you can under the circumstances that you have. We're going to take the matter under submission and issue a timely decision, and we wish everyone a wonderful week. And that concludes our hearings for this morning. Thank you.